The wheel of justice may grind slowly, but it will surely get to its destination of undiluted justice. But while you wait for justice, have you imagined how that long-drawn case can be settled out of court? Yes, we mean rebuilding a culture of amicable settlement of disputes through alternative dispute resolution. Settle with Laughter is a program tailored to educate, inform, sensitize, and promote access to justice through alternative dispute resolution anchored on mediation, consensus building, restorative justice, negotiation, and arbitration. Join an alternative dispute resolution expert, Barrister Ben Odoh, on Settle with Laughter on Soul TV, Abakaliki. Settle Dispute Television is an initiative of Negotiation Powerhouse Company Limited.
A warm welcome to another moment on television with Settle with the Laughter people, and it's still Soul Television, and my name is Chika Igwe. Our journey continues on the arbitration advocacy. For a very long time now, we've been trying to x-ray what arbitration is all about. I know we've talked about what arbitration is. We have also tried to look at the types of arbitration. That's where we brought to you that we have domestic arbitration, transnational, and customary. We also have forms of arbitration, which we told you about. We have looked at the differences between arbitration agreement and other forms of law agreement. We were also able to handle how arbitral tribunal is constituted and what constitutes arbitral tribunal. We have looked at the differences between arbitration agreement and notice of agreement. That was exactly where we stopped before we caught the big fish last Saturday when we brought to you the former Deputy Vice Chancellor of Nnamdi Azikiwe University, Professor Greg Chukwudi Nwakobi, who actually handled what we talked about as customary arbitration. Today we're continuing on the journey. We really want to know how arbitration typically flows. And as usual, I will not be doing this alone. My name is Chika Igwe, and I have with me the PA Technical to the Deputy Governor of Ebonyi State, who, as a matter of fact, is an ADR expert. Join me as I welcome here Barrister Ben Odoh Uruchi, sir. You're welcome.
It's a privilege once more, Chika.
You know, that staying without you for just one Saturday seemed like eternity. It seemed like, okay, you were gone for so long. It's just that, okay, right now I was just thinking, it's okay, it's just once, but it looked like it's been ages since we met last. Okay, but that's good. I do know the family is doing well, and we are all doing well.
Very well.
And we do know also that you are doing well. I know for some of you that expected to meet him last week, he is here now. Because I know your fans will be thinking, where has our friend gone to? And this business is also still interactive like it will always be. You can visit us on our Twitter handle, Instagram, or the YouTube. We can also chat on Facebook, where you get to tell us how you feel and what you feel and how you think we can together partner to make this job better. And so let me come to you, sir. What exactly or how does it typically flow? I'm talking about arbitration.
Thank you. Well, arbitration has its own typical flow, just like negotiation and mediation. Unlike in mediation that starts with the opening phase, the bargaining phase, the concluding phase, the settlement, and the rest. Now, in arbitration, the typical flow starts with preliminary meeting. Now, once parties have appointed an arbitral tribunal, and the arbitral tribunal duly constituted, now it is incumbent on the arbitral tribunal to convene first meeting with the parties that have appointed them, the tribunal. The meeting between the arbitral tribunal, remember I told you, even if it's one arbitrator, that one arbitrator is a tribunal. Even if there are 100, they are tribunal. So we refer to them as tribunal and the person as a tribunal. So once the arbitral tribunal is properly constituted, in accordance with the provision of Section 7 of the Arbitration and Conciliation Act of 2004, it is the duty of the tribunal to convene first meeting with the parties that have appointed the tribunal. That first meeting is called preliminary meeting. Now, at the preliminary meeting, the business at the preliminary meeting are very simple. Number one, it is the first meeting between the arbitral tribunal and the parties appointing the tribunal. Now, it is in that preliminary meeting that the tribunal appoints a registrar or a secretary who takes the minute of the proceeding. Now, if the parties on their own are appointed a registrar or secretary to record, because the arbitral tribunal cannot be arbitrating and be recording the proceeding at the same time. They may be distracted. Okay. So, but while the proceeding is on, they usually have a person known as the registrar or secretary who records every transaction in the proceeding. Now, if parties on their own have appointed a secretary or registrar, the duty of the tribunal at the preliminary meeting is first to confirm such appointment. I don't know whether you agree what I'm saying. Yeah. Now, but if the parties on their own have failed or are unable to appoint a registrar, the tribunal during the preliminary meeting will appoint a registrar, subject to the approval of the parties, or the consent of the parties. Now, once a registrar is appointed or confirmed, the registrar starts taking the record of the proceedings. Now, at the preliminary meeting, pleadings are filed. I don't know whether you agree what I'm saying. Pleadings are filed or statement of cases. The point of claim from the claimant will be properly filed. Remember, I told you the first meeting between the tribunal and the parties. Okay. Now, so it is the duty of the parties, the party A, who is the claimant, to file his point of claim, and party B, who is the respondent, to file his point of defense. And point of claim and point of defense joined together is what we refer to as pleading or statement of case. Now, if it is filed during the preliminary meeting, it is also the duty of the arbitral tribunal to agree with the parties on the method or the mode of the proceedings. Section 20 of the Arbitration and Conciliation Act expressly provides for 3 methods of arbitration proceedings. The first is on oral hearing. Parties can agree that the proceeding should be by oral hearing. The second is by document. Now, parties can agree that the arbitration proceeding should be by document. That's to say, everything you need to plead, put it in writing. Your argument, the claimant, all your arguments, all your claims, all your reliefs, all your prayers, put all of them in writing and come and file it. Now the arbitral tribunal will do what? They will go home and read what you have written and come out with their judgment. So under Section 20, they can either agree that it should be by document, or the third one, that it can be by both oral and document. Now, it is during the preliminary meeting that the parties agree with the tribunal on the method or the mode of the proceedings. Now, if they agree that it should be oral, everything will be done oral. If it is by document, they don't need to talk. They just need to file, put everything in writing in form of written address and file it. Now, if it is by document, it means, if it's by both oral and document, it means that they will put everything in writing, file it, and argue it thereafter. I don't know whether you agree. Yeah. Now, also during the preliminary meeting, the venue for the hearing is agreed upon, because it's not where the preliminary meeting is holding that the parties may end up having the hearing. So maybe now I am the arbitrator and I have confirmed the preliminary meeting here in Abakaliki. Parties can say, okay, the venue for the hearing, it is section 16 provides that unless otherwise agreed by the parties, that the arbitral tribunal shall determine the venue of the hearing at the preliminary meeting. Now, the venue of the preliminary meeting may not be the venue of the hearing. Why? Because, assuming I am appointed as an arbitral tribunal and I'm domiciled here in Abakaliki, okay, and then the subject matter, assuming maybe it's a land, or let's just say land or just immovable property. Let's say the land is in Cameroon and the dispute is between a national of Ghana, the person is from Ghana, and the other party is from Senegal, and I am from Nigeria, resident in Ebonyi. Now I can convert a preliminary meeting here in Ebonyi. Remember, the subject matter is in Ghana. The other party is in Cameroon. The other party is from Senegal. Now, it is at the preliminary meeting that the parties will agree, okay, let us move to the place where the subject matter is situated, okay, which is Cameroon. Or let us go to a neutral place. As party A is from Senegal, then party B is from Ghana. Let us have it in Nigeria, or let us go to London, or let us go to Kenya and have it. So it is the duty of the parties, or otherwise agreed by them, to notify the arbitral tribunal. The arbitral tribunal on their own can agree on the venue of the hearing, okay, where the hearing will take place. All these things are done during the preliminary meeting. Now, the language. Section 18 provides that, unlike litigation, the language of litigation is English language. You can hardly go to court, even if you don't understand or don't know how to speak English language. When you go to court, they provide an interpreter. So the court don't hear Igbo language or any other language except English. Now, in arbitration, English language is not the language of arbitration. Section 18 provides that the parties shall determine the language they ought to use, or unless otherwise agreed by them, the arbitral tribunal can do that for them.
But is there any serious reason for the arbitration now deciding, the parties coming to decide the language they want to use?
Of course, yes. You see, because the parties have, I told you that one beautiful thing about arbitration is that parties have control of the process. Okay. It is their matter. They decide what happens to that matter. Like the example I gave you, Party A is from Ghana. Party B is from Senegal. The subject matter is in Cameroon. And the arbitrator is a Nigerian. You can see English, French. Now, the parties can determine, okay, let us use English language, or let us use French, or let us use German. You get what I'm saying? And then we now provide interpreters. So they can agree on that. Now, let me just bring it back home here. Now, a typical Abakaliki man may not flow or understand the dialect of an Ntezi man, okay, here in Abakaliki. Now, a typical Abakaliki man may not flow with the dialect of a typical Afikpo man. Now, assuming the subject matter is between an illiterate from Afikpo and an illiterate from Ikwo. Now the parties can agree on, okay, let us bring interpreters. Let's use English language, or let us use Central Igbo, or let us get people that can interpret Ntezi dialect and Afikpo dialect. So it is the duty of the parties during the preliminary meeting to agree, because they want to achieve justice. And that they have the control of the process. So they are allowed by law. Remember, Section 34 of the Arbitration and Conciliation Act provided the court shall not intervene in arbitration matter, arbitration proceeding. So parties have control of the process. So it is their duty to say, okay, because we don't want to go to court, allow us to resolve our matter in our own interest, in our own best way. So that's why they are allowed to choose a language best convenient. Now let me give you an example, sir. You know why all these things? Sometimes this language may mislead, sometimes the way this language is presented, if it is in litigation, if you are not careful, someone who is not known, who is not used to that language, may commit himself in the process using English language. Okay. Especially, that's why they are allowed to choose the language that can flow and communicate. Okay. I'll give you an example, sir. There was this murder case in court where it happened in Owerri. The accused person, it's an illiterate that can hardly speak or understand English language, and it was a rape case. So during the course of his plea, the court now asked that man whether he was guilty of the offense charge, which is rape. Because the man is an illiterate who cannot flow, who cannot understand or speak English language. So he needed an interpreter. They brought an interpreter who was not good in interpreting English language and misinterpreted. So when the judge asked him, "Are you guilty of this offense charge?" The interpreter now asks, "Now judge is say, because it is whether did you rape this person?" That was the question the judge asked. So the interpreter asked the man, "No, judge say, eraronya." That is the interpretation he gave. The man said, "Yes, araramia." But that is not what the judge said is, "Did you rape this person?" Is different from, but what the man answered, or what the man interpreted is, "Did you sleep with this person? Did you have sex with this person?" Not rape. So, and the judge understands English. So the man said, "Yes, araramia." Judge repeated again. "I ask you again, did you rape this girl?" The interpreter interpreted again. Judge said, "Eraronya, araramia." The judge now became angry and had to interpret properly. Or you see the man, "Eraronya nike," which is different from Era. Are you getting what I'm saying now? Yeah. The man said, "Bam, bam, 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 bam. Aramia, araromia nike, okwerekwe, enyimwai." I don't know whether you get what I'm saying. Ordinarily, he had accepted, he had pleaded guilty that, he raped that person. But if not for the knowledge of the judge, who properly interpreted he had to now deny that. So in arbitration, these are one of the things why in arbitration, parties are allowed to choose a language that can flow naturally, be comfortable to get to the end of their matter. During preliminary meeting, sir, during preliminary meeting, now the discoveries are made and inspection. Now, when parties file when the claimant files his point of claim, and the defendant or respondent files point of defense, now there are matters that have any matter that have been agreed upon, any fact that have been agreed upon need not to be further proved. That's the position of law. Okay. But sometimes, if one of the parties is hiding a fact that you need to know to assist you in the proof of your own fact, and is concealing it, or he's in custody of a document that you also need to file in order to support you in winning your matter, and is hiding it, what do you need to do? That the party will be empowered to cause the opponent to produce that document or to make known that fact that you need to know in order to support your argument. That is called discovery. So during preliminary meeting, discoveries are made. Now, if it is discovery of fact, now what we refer to it as interrogation, where the party is allowed to further question the opponent who is concealing a fact that the other party need to know to support in the case. Now, during preliminary meeting, date to visit the locus in quo, assuming the subject matter is immovable, like we said, like the example I gave, the subject matter is in Ghana, and we're in Nigeria, and it is immovable. Now we can agree on a particular day, we call it visit to locus in quo, to go and see the subject matter before coming to continue the proceedings. Now during the plenary meeting, date for hearing, date for pre-hearing meeting are all fixed. Now documents to be tendered are made known and pleaded, because anything you fail to disclose to the arbitral tribunal, you cannot tender it thereafter. So you make it known there. Those documents are made known so that party A will know what party B intends to adduce and documents intends to produce. And then number of witnesses, the type of witnesses, this to enable the other party, to enable both parties prepare for enable party A, prepare for, maybe the claimant must know the witnesses that the respondent intend to call, the documents that the respondent intend to produce, to enable him prepare for his case. Now, the respondent also needs to know the one that the claimant wants to adduce, the witnesses he wants to call, then all the documents he needs to tender to enable him also prepare for his defense. All these things are made known during the preliminary meeting.
No, sorry, before you move on, does that imply that, okay, there will be no space for you to forget anything? Like within the preliminary meetings, okay, you forgot, okay, you said all the documents need to be submitted. The opponent, if I may use that word, will need to know who and what he is contending with. So if for any reason maybe somewhere along the line, it was an oversight and I forgot to drop a particular document, does it mean that once we move out of the preliminary stage, I'll not be expected to present that again to still make my case clear?
No, absolutely. The second, we are talking about typical flow of arbitration.
Yes.
Now, assuming in this case, if the parties are not able to remember those things, the second stage is the pre-hearing, where these issues will be addressed.
Okay.
Are you know what I'm saying?
Right.
Now, during one beautiful thing about arbitration proceeding is that arbitration proceeding hearing date can be any day. It can be juridical day, it can be non-juridical day, just like in court. The court days are between Monday to Friday. When in arbitration, you can fix it on Saturday, you can fix it on Sunday.
Okay, is that what you mean by juridical?
Yes.
Because sometimes if you remember, we are not lawyers now.
So it can be fixed any day, even on public holiday, on Sundays, anytime, unlike the court. So you can just fix it. Now, and then once all these things are read, all these things are set, now order for direction is also made during the hearing, the preliminary meeting. That's to say, what are the laws that will guide the arbitration proceeding? Are you know what I'm saying?
Yes.
Like an example I gave you, I'm here in Nigeria. The subject matter is in Ghana. Are you know what I'm saying? When we talk about land matter, the Land Act of Ghana should govern land that is in Ghana. Are you know what I'm saying?
Yeah.
Now the other party is from Cameroon. The other party is from Senegal. Now which law do we use? So we agree on that law. Are we going to use Nigerian law to determine what is in Ghana? So all those laws are agreed upon during the preliminary meeting. The order for directions are also made. Then during the preliminary meeting, cost, very, very important. Mm-hmm. Arbitrator's fee and administrative fees costs are made, agreed upon. What should be the cost of the arbitration proceeding? The fee, the remuneration of the arbitral tribunal. Section 49, Section 50 provide for that. And Section 49 provides that once it's agreed, there will be a deposit. Assuming the parties have agreed that, okay, the arbitral tribunal have taken into consideration and said the cost of the proceeding is 1 million. Okay. It is the duty of the arbitral tribunal to make a deposit, at least maybe 500 or 300,000, to commit the arbitral tribunal that they are serious before they cannot fix date for pre-hearing. Pre-hearing is the second stage. Now, during pre-hearing, what do we do? Specifically, what we do during the pre-hearing is that, number one, issues for determinations are made. Number two, issues for considerations are made. There's a difference between issues for determination and issues for consideration. Then, three, now bundles of documents are examined. Those documents you agreed during the preliminary now are properly examined during the pre-hearing. Now, the locus visit to locus in quo too. And then if there is any further orders necessary, they will be made during the in fact, the crux of the pre-hearing meeting is to consolidate the positions of the parties, like what you asked,
yes,
to know whether they have complied with the agreement reached at the preliminary meeting, and then consolidate their position and see whether there were issues they forgot during the preliminary meeting so that it can be consolidated.
In other words, in the pre-hearing meeting, the disputants are all expected to be around.
Very well.
Do they pre-hear them individually?
No, there's a second meeting between the disputants and the arbitral tribunal.
Okay.
So they come. Now I said issues for determinations are made. Issues for considerations are made. Now when we talk about issues for determination and issues for determination are issues based on fact. Issues for consideration are issues based on law. This is the fact. Now, upon this fact, this is the issues for consideration. This is the law. This is the position of the law. And then this position of the law will be applied to that issues of fact.
Okay.
Are you going to say they are made? And then, like I said, bundles of documents are examined. And then, if there are further orders that are necessary, then they are also made at the pre-hearing. Then a date for hearing is fixed.
When you say further orders, is it the ORD or the...
When I say further orders, which means further order, O-T-H-E-R, order, O-R-D-E-R.
I want to be sure.
So that's what I say, further orders
I will also know
are made if necessary.
If I'm learning a new one, because today I got juridical, okay, let me also know that there will be a point in legal profession where you now have of the orders.
Yes. You make an order now, an order is
but
rules,
now, okay, I've known that the order and
yes,
order.
Yes.
So it's all right. Let's get into the hearing proper. If all these things will be happening before the pre-hearing, what exactly happens during the hearing stage?
Thank you very much. Now, during the hearing, it starts, like I said, the hearing is the crux of the arbitration proceeding. Now, during the hearing, the aggrieved party, that is known as the claimant, is the one that commences by, is pleading. He commences, call his matter, call his witnesses, and then examine the witnesses. I don't know whether you agree what I'm saying. You see, one beautiful thing about arbitration is that, what determines in law, in litigation, relevancy and admissibility of any evidence is determined by the Evidence Act of 2011. So it is the Evidence Act that determines documents or anything that is relevant and admissible. Any evidence that is relevant, any evidence that is admissible is determined by the Evidence Act of 2011, and that guides the court in litigation. But unfortunately, Section 256 of the Evidence Act 2011 prohibits Evidence Act from being applied in arbitration.
Okay.
I don't know whether you agree what I'm saying now. So, Section 256 provides that the Evidence Act shall not apply before arbitral tribunal, court martial, or any tribunal. So you cannot use the Evidence Act in any matter involved where you have to appear in court martial. You cannot use it in arbitral tribunal, and you can also use it in any tribunal proceeding. Okay. Now, if the Evidence Act, Section 256, prohibits Evidence Act, are you know what I'm saying, from being applicable in arbitration proceeding, now how is relevancy and admissibility of evidence determined in arbitration proceedings? Now, so because of this prohibition, now relevancy and admissibility of any evidence in arbitration proceeding during hearing, are you know what I'm saying, is at the inherent discretion of the arbitral tribunal.
Okay.
Did you get what I'm saying now? Ordinarily, the Evidence Act is supposed to guide them in determining relevant evidence and admissible evidence. But because Evidence Act under Section 256 prohibits that act from being applicable in the proceeding, now relevancy and admissibility of any evidence is at the inherent discretion of the arbitral tribunal. So it is the arbitral tribunal that determines what is relevant and what is admissible. Did you get that now? Yeah. Now, because of that now, they don't use Evidence Act. So they are guided by the Arbitration Act and any other law or any other order made by the. That's why I said further orders they can make to guide them. Now, so knowing this now, during the hearing, the claimant commences his matter, calls his witnesses, and then, under the Evidence Act, there's provision for cross-examination of a witness. Now, because the Evidence Act now prohibits the Evidence Act from being applicable in arbitration proceeding, during hearing, we do cross-examination, but we don't call it cross-examination. We call it questioning. Okay. So you question. So once the claimant, brings his witnesses to testify, the respondent has the duty to question, especially where the witness is lying, especially lying on oath. You can question the witness, either by cross-examination or what we call it questioning. Are you getting what I'm saying now? Yeah. Now, when the claimant is done with his matter and the matter ends, now the respondent is expected to open his own matter with his point of defense, bring his own witnesses, bring all the documents that he's relying on to prove his defense. Are you getting what I'm saying now? Yeah. All these things happen during hearing. Now, during hearing, sir,